Tim McKibbin from the REINSW joined me this week to talk about the very important area of cooling off.
What is cooling off?
As the name would suggest, it is an opportunity during a very, very small period of time for the purchaser to be able to reverse out of the contract.
So it's a period of time then that you're allowed to get out of a contract, but my understanding is that it's not the same period of time in every state.
That's correct. In Queensland you have 5 days, New South Wales 5 days, Victoria 3 days, South Australia 2 days, Western Australia there is no cooling off, similarly with Tasmania. Northern Territory there's 4 days, and in the ACT, as I understand it, there's also no availability for cooling off there as well.
Why is cooling off allowed in the first place? One would think that by the time you sign a contract, you've had plenty of time to work out whether you really want to buy.
The policy influences that led to the cooling off period are a variety, but certainly I think there's a recognition that people will come to a property with a degree of emotion. They'll say, I've fallen in love with this, I'm going to buy it. And on previous episodes we've talked about the significance of the acquisition. It's the big one we're going to make for many of us in our life. So they buy the property and then they go away, and as the name would indicate, they cool off a little bit, start to get an idea about exactly what they've committed themselves to, and say, do you know, maybe I'm not ready for this, maybe it would be a very good idea if I reversed out of it.
If you do reverse out of a contract during the period of cooling off and before it's expired, is there any penalty? Yes,
a good example would be New South Wales. There's 0.25% of the purchase price, and you know, obviously that can be a significant amount of money, but better than having to be committed to the whole acquisition if you're not ready for it.
So how do you enact your cooling off rights?
You go to your solicitor or your conveyancer, and you need to be very prompt about this once you've made that decision, and you go to them and say, I wish to reverse my way out of this contract, and you tell them that, and they serve the notices on the other side of the transaction onto the vendor, solicitor or conveyancer, and affecting the cooling off option.
Is it something that happens very often?
Not a lot. Typically people have, I guess, gone through that process themselves, made a very, very conscious decision. Sometimes the cooling off period, I think, is used in circumstances where somebody actually wants to lock the property down. So they turn the thing around a little bit and say, what I'll do is I'll grab this property, I'm very, very frightened, I'll lose it. So I'll grab it now, and then I'll start my my due diligence process. So they go and do their various inspections, and they're prepared to wear the costs if they need to get out.
So if it's an auction, you don't have cooling off, do you?
Correct. That's a very good point. At the fall of the hammer, you own that property, and it just goes through the process, and there is no opportunity for you to rescind the contract.
Why is that?
Auctions are a very, very certain process, and that's part of the beauty of them. I think it's a good point you make, though, because some vendors will insist that the rights of the purchaser are, even in a private treaty contract, that the purchasers give. They want certainty as well, and the auction process will provide certainty.
Tim, I've heard the expression used out there, sign on a 0.25, in reference to what a buyer might do with the property. What does it mean?
Well, normally what happens with a contract for the sale of property for real estate is that you would be exchanging on a 10% deposit, and that's the norm, the standard. Sometimes people will say, well, look, I'll exchange now, and I'll exchange on a 0.25, and as we discussed, that's the penalty for exercising your cooling off rights. So that's a pretty clear indication really to the vendor's agent. These people are contemplating exercising their cooling off rights.
So as a vendor, maybe be wary of that kind of a situation.
Yeah, there's a whole raft of law that sits behind deposits, and as a vendor I would be very reticent about, I guess, accepting a 0.25% deposit.
Having said that, you don't have to pay 10% either. People think it's mandatory, but a deposit can be whatever the purchaser and the vendor agree upon.
Correct. The purpose of a deposit, I suppose, is to compensate the vendor if the property, if the transaction falls over, to compensate the vendor, at least in part, for the inconvenience and costs that they've incurred.
Now I'd like to talk about a different kind of a cooling off now, and I'm at the moment trying to sell my own home, and I noticed that when I signed up with my agent, I actually had a cooling off period for that agreement too.
Correct. You've got two opportunities there. You can say, I no longer wish to proceed with the sale of my property, and I no longer wish to proceed with the services of this particular agent, because once somebody obviously is engaged in a contract, they start to commit serious resources to it, and for that reason people want to be some certainty about the contract. So it does provide the client, in this case the vendor in your case, with the opportunity to rethink it over a few days.
So how can somebody find out a little bit more about their cooling off rights?
You could contact the Real Estate Institute. We'd be happy to respond to those sort of questions. In relation to their legal rights with the under the contract for sale of land, and that's obviously enshrined in the legislation itself. Speak to your solicitor, speak to your conveyancer, and certainly that would be an issue they'd be very cognizant of.
And of course, all states have the governing body for their own real estate acts. Usually it's the Department of Fair Trading, and many of them have fact sheets that you can get just by going to their website.
Yeah, their website would be the logical place to start, and you are correct. We in New South Wales, we call it the Department of Fair Trading, and they have the same horse, different names around the country.